Okay, it is 7 o'clock, Tuesday, October the 16th. Welcome to week 3 of Introduction to Criminal Justice. And week 3 signals the midway point. After this week, we'll have 3 more weeks to go. So it's kind of like um, halfway or mid-quarter already. And I hope that you have uh, gotten oriented to the requirements. Week 2 written assignments were just completed on day before yesterday, and so we will be getting those out to you by the end of the week. And that's your first written assignment. So you want to make sure that you pay attention to how the rubric is graded. It's very important. And also you want to make sure that you run your papers through Grammarly. Very, 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 very important. A few of you have already gotten some grades on them, and I've gotten some calls or questions about that. So anyway, make sure that you follow the rubric and what is in the module. Very, very, very important. So I'm going to go ahead and get started here by sharing my screen. Okay. And you have here familiarity with this. Whenever I say course home page, this is the page I'm referring to. And it tells you things that are very important that I went over in the open house that I will not go over again. And so down we come to the fact that rubrics are located with each written assignment, and so that our lecture for week 3 is taking place right now. And then you must provide me a keyword. I give the keyword during the course of the lecture. I've had a couple people call me and ask me, could I? They couldn't find it. Could I tell them what it is? I said, I can't do that. That's not the way it is. I've had a few people where I could tell that what has happened is some people were trying to glean through it just to get that. Well, you do yourself a disservice if you do that, because the lectures actually clarify some of the materials in the written assignments for the week, as well as the requirements. And it gives you an opportunity to be able to get a higher grade. So let's take a look at what it says here in our week 3 module. In week 3, I did not post what was the topic, but the topic is limitations on law enforcement and ethical issues in criminal justice. That's the topic, and that's what you'll find in the module 3, chapters 5 and 6 of criminal justice. The textbook is what you're going to be reading, and that you're going to go over the lecture notes, which I'll be talking about, limitations on authority of law enforcement, professionalism, and ethical issues in criminal justice, and then there's a practice activity for you as well. And then your written assignment will be professionalism and ethics in criminal justice. That's your discussion assignment that is due tonight at 11:59 p.m. Central Standard Time. And then your reply post is due Saturday at 11:59 p.m. Central Standard Time. I've already elaborated to many of you on what I expect, let you know by your grades that you saw in week 1's discussion post, what I expect, and making sure that you do follow the rubric. But your content relating to the issue in this week, professionalism and ethics in criminal justice, is what I'm going to be looking at the most, and I'll be responding to some, posting some responses to some of your posts, and then sometimes I post a comment of my own. Finally, the written assignment, limitations on police authority, and we're going to talk about the requirements for that assignment, and then the timed quiz. Again, I recommend to students that the quiz be done at the end of the week so that you can make sure that you are able to score well. Once you start the quiz, it keeps going. And you should have studied the materials by that time and gone over it. And then my motto, Adversity Springboard to Success, you know what that is all about. And you found that out by my week one lecture. So, okay. So now let's take a look at the course calendar. Okay. Course calendar is here. And the course calendar where we are this week is the 15th, and it tells you your reading assignment. Again, you click on it, and it tells you the things that I just shared a few minutes ago with you. It tells you your initial post, the live lecture taking place, your reply post due on the 20th, and then your written assignment. Now, you got two written assignments here, but one is, if you click on it, it will say quiz, and the quiz is timed. So that and the written assignment itself, that is not the quiz, will be found in the rubric and module. Again, I'm going to go over that in just a few minutes, so hold on to that. So every week, that's how you find out when things are due. By the way, somebody asked me about why does it say double in there? Because the check marks represent the due dates that are in the rubric that tells you when the assignments are due. So, for example, it tells you that the written assignment, and it gives you the due date, which is Sunday. And then the other one, it gives you the quiz. So they're both due. So that's what that is. That's not double assignment. So the check mark is there for purposes of that, to remind you of the due date for those assignments as well. All right, so now let's take a look at Module 3, Limitations on Law Enforcement and Ethical Issues in Criminal Justice. Again, let's go over the assignments. So now, here is your assignment, and I'm not going to go over all the facts. So you're going to read the fact pattern. The length is always given here, and you're going to see it in the rubric, 2 to 3 pages. And you must address these 4 bullet points. Citations in the body of your paper, along with a reference page. That's the APA requirement. APA citations and formal requirements. Citations in the body, references in the end, and a cover page. You must include proper citations to any source that you rely on and include in your paper. Now make sure you run your papers through Grammarly too, so that you can make sure that you haven't taken more material from the sources than your critical thinking. And your critical thinking is very, very, very important. I had a student that say to me, you're grading me on my opinion. I says, no, opinion is only one part of it, but the analysis of the issues reduced to paper in your writing demonstrate to me that you did not only research it, you didn't read it and research it, but you also analyzed it. And so you'll put down that in your paper, and that will provide you with a very, very good paper. And then there's a scoring rubric, again, which you can click here. And there's also guides again. to remind you for introduction into criminal justice. And in those guides, there's a written assignment requirement, online library that helps you with your research, toolkit for APA, again, as we keep talking about it, and tutoring and writing lab if you need those as well. I do encourage you to make sure that you utilize the resources. Particularly if you're having trouble with APA, we have so many resources that are very basic to help you understand the importance of APA. And just so you understand why we are harping on APA is because of the fact that when you leave school, you're going to have to do research projects, and you're going to have to give credit to the sources. But then the person or parties that you prepare the research for want to know your analysis of it. What did you observe, or what critique did you have of it? And that's the kind of thing that we want to see for critical thinking, and to get you into the habit, because employers have told us through our advisory boards that our transferable skill of critical thinking is so important. I hate to say it like this, but it's critical. But the point of the matter is that means it's essential. Very, 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 very important. Doesn't do yourself a service to just learn how to copy and paste. We don't want you to do that. We want you to be able to provide analysis detail. Again, if you have any questions, there is a video on the course homepage. Copy it, the link, put it on, and take time to look at it so you can get an understanding. So there are two very important things that you need to grasp that will help you with your assignments: critical thinking and APA. Critical thinking and APA. So anyway, here's another way to see the rubric, and this is the one that I actually use, which is the same one. I just added the points all together. It's still, and it tells you the due date. That's how you got the check box there in the box for the calendar. It tells you that I took 20 points, and that's what you get for quality and content. All I did was add the 10 points for each one that you saw in the other rubric. And then the 3 points are for grammar. And then your citations and references. Only in this class will you get 2 points off for not doing APA citations because you're new, and your introduction to criminal justice gives you a chance to succeed. We're a little easier. Normally we take 5 points away. But even with this, if you don't do your citations and references and your cover page right, you're going to end up losing your, let's say you don't do citations and references, you're going to lose 2 points. If you don't have a cover sheet, you're going to lose another point, which is a 3rd point. And then your writing has to be constructed properly, and it has to meet the 2 to 3 page minimum requirement. And you might wonder, says, why do we have 2 to 3 pages? Is because we've determined that that's the right amount of writing that is necessary to address these issues adequately. By the way, if you're going to discuss a Supreme Court case, make sure you have the proper citation for the U.S. Supreme Court case. You can look it up through the name, and you'll be able to find it. It'll say something like a number, then it'll say U.S., then it'll say another number, and then in parentheses it'll say the year that the case. And that's how you properly cite a U.S. Supreme Court case. All right. So moving back to our next assignment, other than the quiz, is the discussion post. Professionalism and ethics in criminal justice. Very interesting scenario. Now, let me say this to you. Don't be concerned if you see me come back and say, I don't agree with you because blank, blank, blank. That doesn't affect your grade. I don't want you to write to agree with me. I want you to write your perception on what you feel based on your maybe experience and what you feel. Some of you have gone back and applied your state, which is a good thing, because that's something that you probably want to do, because that is probably 9 times out of 10 the state or jurisdiction that you're going to go ahead and work in whatever criminal justice you do. So it gets you familiar with what the state law is for certain things. And so this initial post, it tells you what to do, and then you're going to respond to someone who identified a different ethical dilemma from what you discussed. Compare and contrast your dilemma and other solution to the scenario. What you're doing then is you're applying what we call critical thinking. That's what I was talking about. And you know when those are due. And then your quiz. 25 questions, timed. You have 40 minutes. And you're going to make sure that you abide by the academic misconduct policy. In other words, you don't have your books open. This is a closed book exam. Of course, though, you should be aware that you probably are not going to be able to finish it adequately unless you have studied the material. I did provide to you the PowerPoints, which is a summary of the chapter. And if I would submit to you that if you do the PowerPoints and then pay attention to the lecture, particularly the sections that we're getting ready to go over, that you will be prepared for taking that test. Okay, let's go right into lessons. If you think of any questions, feel free to type in, and I will pause to answer those questions. My job is to try to help you simplify the assignments, not complicate them for you. I am not going to teach this class the way I would if I was trying to prepare you to be a lawyer. I would go much more in detail. We scratch the surface. We discuss general details of the law so that we can prepare you to have what we call a working knowledge of it. Should you decide to go deeper, you go where I went. That was to law school. And then you would end up studying that. So in this module, we're going to describe how the Constitution and Bill of Rights limit law enforcement. You can recall on your course homepage and that I sent you the Bill of Rights, and I pretty much told you that one of the biggest constitutional issue of the Bill of Rights that limit the authority of police officers in criminal cases is there are 2 of them, and they're back to back. Does anybody know what those 2 amendments are? Just off the top of your head? Either one or both? You can type in. Which one of the Bill of Rights limit the authority of law enforcement in criminal cases? Which 2 are really the big ones that you will run across as in law enforcement? Anybody? Somebody's got to know at this point, that this far into this course. What is it? You can type it in the chat box. I will see it. That's one of them. The 5th is one of them. What's the other one? And actually, there are 3 that get together, but actually the one I'm thinking of, law enforcement is always involved with this one. Always. Well, kind of the 6th, but that's right to counsel. That fits within it. But there's one that is like it's there. Everything you do in law enforcement, it affects that. It's that. Which one? No. Okay. It's the 4th Amendment, search and seizure. you're going to be involved in that all the time, even if you deal with stop and frisk. It's still Fourth Amendment right. Search and seizure. That is the biggest one that you will be engaged in law enforcement, followed by the Fifth Amendment. That is the incrimination issue, but you deal with that in Miranda, advising people of their rights to remain silent and letting them know that anything can and will be used against them. That's the Fifth Amendment that applies. The Sixth Amendment applies to a point because it's part of Miranda, but it primarily involves the right to counsel. So when I talk about the law enforcement aspect of it, we talk about pretty much the Fourth Amendment, number one, the Fifth Amendment, number two, and maybe a little bit of the Sixth Amendment. And if you stop and think about it, what you're doing as a law enforcement officer, the first thing you're going to run across is probably the Fourth Amendment, because it involves your interaction with individuals. We're going to get to that a little bit more in detail. Specific constitutional limitations on the authority of law enforcement relating to search and seizure and interrogation. That's why 4 is the search and seizure and 5 is the interrogation. Okay? So discuss misconduct and the role ethics in the criminal justice field. So we'll get into that in a little bit. Again, these are the assignments. Your quiz, your live lecture, which you're in now, and then your written assignment and discussion, which I've already gone over with you. So let's talk about the limitations on law enforcement. You see what I told you? You see what the first one we're discussing? The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, particularly describing the place and the persons or things to be seized. So what this means is this, is that police officers are bound in order to perform their duties, that in many instances, most instances, there is a requirement that before they can search a person or an area, they must obtain a warrant. Now, there are some exceptions to that, which we will talk about a little bit, but just be aware that in most cases, there are, and it must be upon probable cause. Probable cause pretty much means that the individual will provide sufficient evidence in an affidavit that is filed before a judge or a magistrate, indicating what they believe or what they believe they will find based upon some information that they have. And the judge will determine if it's adequate. If the judge issues the warrant, the judge's basis for issuing the warrant means that it must meet the probable cause standard. Now, stop and frisk is not the same. It is what we call a Terry stop. That's the name of the case that it came out of. It is a brief stop where an individual is detained for questioning, and the officer is allowed to conduct what we call a pat-down search of the individual for purposes of determining if that person has weapons. And that's the purpose of this. So individuals sometimes say, well, the law enforcement people are hampered. No. There are procedures as to how you do things, and it must be done right. We lawyers who were defense attorneys, as I was many times, would file a motion to suppress because we believed that the search violated the Fourth Amendment, unreasonable search and seizure. In other words, what we determined is even if the person went and did the search, they didn't get a warrant. They didn't have a warrant. And we can also argue sometimes on appeal that even if the judge rules probable cause, that the judge could be mistaken, that the evidence as viewed by an appellate court or a higher court says, oh, that judge was wrong. And so we deal with the Fourth Amendment here. So it is our privacy that we are protecting in this country. And people says, well, you know, criminals. I said, no, everybody has a right. Remember the presumption of innocence until proven guilty. So anyway, the bottom line is that you can't invade a person's home or private area or even in their car. There are certain stop rules that are involved. And so there has to be a standard, and probable cause is the basis as you go through and you read these notes that are included in this module. The concept of neutrality, that is, a judge, emphasized that the warrant will be issued by someone who is neutral, that has no prior knowledge of the case or interest in the case. That's the trier of fact, and that's what the person is who issues the warrant. Okay? Now, I want to read this one straight up to you. And an important point to remember is that the Fourth Amendment does not protect all searches and seizures, but rather only unreasonable search and seizures. And you should also be aware that it does not define the phrase probable cause. So the Supreme Court interpreted probable cause through cases that are brought before them based upon the facts and information of each case, from which a reasonable person would conclude that a specific person has committed a specific crime. Though that's the basis for analyzing or understanding probable cause itself. And it's done on a case-by-case basis. So these are some of the exceptions to the warrant requirement that I'm going to just go over just quickly here before we get to the next one. Stop and frisk. I already explained that to you. Search incident to an arrest. That means that a person they're able to search incident to an arrest. If a person is under arrest, then that person can be searched because of the fact that they're under arrest. And so the purpose for that search is to protect, is beyond stop and frisk, but that person is under arrest. Now, let me say this to you so you'll know this, because this is going to apply when we start talking about the Fifth Amendment in a minute. And it is important for you to know that a person is under arrest when they are not free to go. So there's a simple question that a person can ask, and that is, can I go? If the police officer or law enforcement officer says no, that means you are under arrest. Be aware of that, okay? And that's the point at which, if you're going to question somebody, that you should Mirandize them, give them the Miranda warnings. But very important, very important. And so sometimes we get cases thrown out with some of these exceptions where they try to stretch them. A protective sweep, that's when you're trying to preserve evidence and things of that nature. Automobile searches. Now, let me explain to you about automobile searches. Automobile searches can be done in situations because vehicles are mobile. However, there are some issues with going into things like the trunks, the glove compartment, and things like that. Really the trunks, because the persons in the vehicle don't have absolute control over that. For example, if the officer says, can I search your trunk, and you say no, then they can hold the vehicle and then obtain a warrant based upon some probable cause and an affidavit presented to a magistrate, and then open it from that particular point. But automobile searches has more issues, and I won't go into all of them. Just be aware, it's not a blanket. It's not a blanket, and there are some instances where it does violate the Fourth Amendment. Plain view. It means what it says. If you, for example, as a police officer, law enforcement officer, observe in your vision, and you're at a place where you are supposed to be, let's say you're in a public place, or if you're invited in somebody's house and you're in there just talking to them and you see drugs or drug paraphernalia, well, you can almost be rest assured that if there's drug paraphernalia, that probably reaches the level where there's drugs. So then that's considered what we call plain view. It means just what it says. It's in plain view. There are some questions about the ability of a law enforcement officer to be able to smell drugs, such as marijuana. But there are also rules relating to using dogs. Now, I want to tell you up front, right now, that there are some, the case law is where it is right now, is that a dog sniff is considered a Fourth Amendment requirement to obtain a warrant before you can use it. So be aware of that. Consent to search. That is, a person says yes, they give, and it must be freely and voluntarily. You know, you put a gun on somebody and says, you agree to let me search, that's not it. You're under duress then. Emergency or exigent circumstances. You're chasing an individual, or an individual may take the opportunity to try to flush down the toilet or throw away or get rid of the evidence. That's an exception, because you don't have to go and get a warrant for that, because it'll be gone. Probable cause, we've already talked about that. Open fields means that it's like, for example, in somebody's yard or in an area that is contiguous with the area that they're checking, or in public places, or either open areas that doesn't have a fence around it, or those kinds of things. So just be aware that the general thing for you to be aware of is the Fourth Amendment involves search and seizure, and that if there may be a fact pattern given that will lead you to one of the exceptions. So kind of be familiar with the exceptions that I've given. Like I said, you don't have to be really heavily involved in it. Your PowerPoint gives information about these as well. So that's the Fourth Amendment. Any questions about the Fourth Amendment before we move to the Fifth Amendment? Any questions? Let me know you're there. So just, you can type yes, you can type no. Just type it in the chat box. No questions. Okay. All right. All right. Well, I didn't hear see nothing else, but I want you to interact with me. Very, very important. I'm not just going to feed you information. So now, the next amendment, remember I already told you, and if you paid attention to these notes at the top, it names them. It says Fourth, Fifth, and Sixth Amendment, just like we talked about a few minutes ago. So let's go back to the Fifth Amendment. And again, as I told you, the Fifth Amendment, again reading it, no person shall be held to answer for a capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in militia, in actual service in time of war or danger, nor any person be subjected to the same offense put in double jeopardy of life. In other words, tried for the same offense twice. Now, you can be tried in state court and federal court, but that's not double jeopardy. But the state can't try you twice if they don't get two bites of the apple or limb. Nor, and this is the big part, nor shall a person, Carrie Ann, you have a question? You want to type it in? I'm going to type the question in, and I'll answer it. Okay, it's very simple. Remember this. Think about it. State, but federal. There are two different systems. They're totally two different systems. So that's why. And then there are two different crimes that are committed. The charges are not the same. So they're totally different levels and how they apply. So in state court, most cases, the case that you come in contact will be tried. But for example, let me give you an example of some cases that apply like that, and I'll show you why. In the civil rights era, there were individuals who committed crimes whose state jurisdiction found not guilty individuals who were totally guilty of the offenses. That's because the state courts in the area were stacked. The juries were stacked. They were either Klansmen or people who would acquit individuals who were clearly guilty of an offense. Then the federal government would come back and file an action, say that you violated the civil rights of those individuals. And it is at another level, and it is removed from that position and taken to a neutral position. Remember, it's supposed to be neutral at first, but it really wasn't. And so what happened is the deck is stacked in the state court. And so then the federal court comes back and says, you did violate the civil rights of the individual, you took the person's life, here's the evidence, and then it's either tried by a judge or jury on the federal level. And that's what it does. It's a check in a balance situation. Now, does that make more sense now to you, given that example? Okay, good. That's a great question. I'm glad you asked it. That's a good question. Sometimes students don't want to, they just accept what's said. I love it when students ask questions. Nor shall a person be compelled in any criminal case to be a witness against themselves, nor deprived of life, liberty, or property without due process of law. Okay, nor shall any private property be taken. So in the loosest form, what this is really saying in the amendment is that in addition to the jeopardy issue, but the compelled in any criminal case to be a witness against themselves, is that the defendant does not have the burden of proof. The burden of proof is on the state, the prosecution, and so they must prove beyond a reasonable doubt that the individual charged with the offense committed the offense either before a judge or a jury. Therefore, the defendant does not have to take the stand to testify. Now, there are times when we lawyers, we defense lawyers, decide not to put a person on a stand. Obvious reasons. Our client may have a record, and if that person takes the stand and they try to testify like they're really a nice person, a good person, and didn't do it this time, the evidence of a prior crime can be used to what we call impeach them or discredit them in their testimony, but it cannot come up if we don't put that person on. So it might be our decision. The other reason we might do it, and this is the reason why I've not done it many times with a client, is I have had clients that we use the term they had diarrhea of the mouth. In other words, they love to hear themselves. So they will just talk, and then once you put it out there on the record, you can't take it back. It's already heard. Even if the judge tells, I object, Your Honor, as a defense attorney, the judge says it's sustained, and then instruct the jury to disregard that. Well, that's for the record. But in common sense, you and I both know that once you're told something, it becomes now a part of your ability to be able to make decisions. I don't know anybody who can stand up and say, I heard this, and the judge said it wasn't right, and so I didn't consider that in terms of my decision. You may do it subconsciously, and you may do it consciously, but because if you're the jury, you're the trier of fact anyway. So the point of the matter is that we don't want to put a person on that might damage the case. I've seen it time and time again. Now, the other part gets to when we start talking about the Miranda warning, which we're going to talk about in just a second. So anyway, the Fifth Amendment limits interrogation and arrest procedures. And then I already talked about double jeopardy. And now due process requirements mean this. Due process means that a person has a right to confront their witnesses, the accusers. They have a right to the evidence that the prosecution has. We file what we call motions for discovery at the beginning of a case, where we are able to obtain what information that the other side has. If any of you saw the movie My Cousin Vinny, you recall that the attorney that Joe Pesci was playing, Vincent Gambini, or whatever names he used, several names, was taught that he had the right to get the files of the prosecution. And the prosecution didn't do it as a favor or because he liked the guy. No, he did it because the Constitution says that would adversely affect his ability to be able to receive due process of law. And and as a result, he discovered the attorney that he could question the witnesses on the other side as well, those kind of situations. So anyway, an opportunity to be heard. So you're not just, now unless you're in grand jury, that's a whole nother issue. Grand jury is not the trial. Grand jury is where there's only one side, and that's the indictment or what we call a true bill, where it's voted to bring the case to trial. What I'm talking about now is it's gone past that stage and it's in the trial stage. And oh, by the way, while I'm saying this to you, you'll learn this in criminal law, but introduction to criminal law. But I'm going to tell you right now that only 10% of the cases, as a general rule, go to trial. Only 10%. So a larger portion deal with pre-trial plea bargains, but we won't get into that. But I'm just telling you. So let's say we're talking about the 10% roughly that actually does go to trial, and then you have a right to a bench trial in which the judge is the trier of fact, or a jury trial, which you generally have 12 and 2 alternates, that's 14, and they are the ones who are what we call the triers of fact. They hear the evidence in the case and make a decision. So now let's talk about the infamous Miranda versus Arizona case. I'm going to give you some insight that only I could give you as a professor. None of the other professors can give you this, and I'll explain to you why in just a second. But Miranda versus Arizona interpreted the wording of the Fifth Amendment to require police officers to advise a suspect of their rights, and when they are in custody. And remember what I told you: you are in custody when you are not free to go and being interrogated. Now, the court said that the guidelines necessary to protect overzealous police activity when the person is in custody and being interrogated. So the person has a right to refuse to answer questions that could incriminate them the same way as in court, or to provide some evidence of guilt. In other words, they don't have to provide anything. They don't have to say nothing, except maybe they can say their name, but they don't have to say anything. The police officers can't force the person to confess to a crime or force a suspect to admit. Now, there have been a lot of instances where there's been some violations of the Miranda. We had a guy who just passed away, chief of police here in our area, Cook County. His name was John Burge. You can Google it, Jonburge, and he was guilty of, in the 80s, and I had clients who were involved in situations where they were actually forced to sign statements or give statements under duress, such as cattle prodding, electroshock, all kinds of stuff that forced the individual to give a confession. And so those kinds of things. But let me tell you about Miranda versus Arizona. In this case, there were individuals who were arrested, and then they were questioned using techniques that were utilized by a book called Interrogations and Confessions. The book was written by a guy by the name of John Reed and Fred Inbau, I-N-B-A-U. Now, when I was in law school, and so the Supreme Court ruled that those techniques were onerous, and to fix that up, they came up with just roughly the Miranda warnings that all you almost familiar with. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney, and then do you understand these rights and so forth. I just gave you a general version of it. So here's what happened, and here's where my inside information came. I had the pleasure of going to Northwest University School of Law, and in 1975, my criminal law class, my professor was Fred Inbau, the same guy who wrote the book that the Supreme Court said the techniques were bad and that violated the Fifth Amendment of the Constitution of the individuals, thus came the Miranda warnings. My professor told us that every time a case came up concerning Miranda after that, he submitted what we call an amicus brief or a friend of the court brief, that on behalf of the National Association of Prosecutors. And what his goal was to provide reasons to the court why Miranda was a bad choice and that it should be overturned and done away with. He told us in lectures that he felt that he was personally maligned by the United States Supreme Court in Miranda versus Arizona. If you read the decision and read the full case and look at the footnotes, you'll see what I'm talking about, the things. And it's a very lengthy case, but it's a very, very, very interesting case. But I was fortunate enough to have the man whose procedures were attacked as my professor, and that's who I learned criminal law from. So I learned it very well. He was a prosecutor. I was more defense-oriented, but I still learned a whole lot sitting under him. And so because I had him, I know some things about Miranda versus Arizona that you can't learn from somebody who didn't have him as a professor. He has passed on since that time. And by the way, we kind of gathered very clearly he was very, very, very serious about this. And he died when and of course Miranda versus Arizona is still good law. I don't think it'll ever be overturned. I don't care how far to the right the court goes. I don't care how many justices that are put on there, that will change. But at any rate, that's what I want to share you about Miranda versus Arizona. It is a very important thing because I learned the context of those issues. I actually read the book, Interrogations and Confessions, that Professor Inbau and Professor Reed and Mr. Reed did. Mr. Reed and him also wrote a book about what we call we call them lie detector tests. But you know what I'm talking about. And there's some issues with those tests that are involved. And he wrote a book with him on that as well. So basically what I am saying to you is that this landmark case of Miranda versus Arizona, I believe it was 66, I think it was in 1966, might be 64. It changed everything. It gave law enforcement some steps that they had to take and protected the rights of individuals. Now, somebody asked me, they says, but don't you think that that they were it was unduly restrained? And I says, I don't think so, because of the fact that Miranda versus Arizona was a case that started law enforcement to follow certain procedures and rules, and that's what it is. It's 384 U.S. 436, 1966. Yeah, I thought it was 66, and that's when that case was issued by the United States Supreme Court. So that's the Fifth Amendment. Okay. The old Miranda. You think of it more in terms of Miranda, but again, there are other things other than Miranda. But the biggest thing that most law enforcement are going to be dealing with Miranda is the decision of Miranda and the cases that came after that. Okay. The Sixth Amendment. Okay, so the Sixth Amendment says that law enforcement have certain limitations. Individuals have a right to, and remember, once again, most of this you'll hear doesn't directly involve law enforcement, but the accused has a right to a speedy and a public trial, except in juveniles, impartial jury of the state and the district where the crime has been committed. Now, impartial in the state and district where the crime has been committed. There are times when people want to move the case to another jurisdiction to get a fair trial, but most of the time that doesn't happen. Which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, and to be confronted with the witnesses against him. I told you about that. And have compulsory process, subpoenas, and motions that you can file in court. But subpoenas to compel people to come to testify. Subpoena ducis tecum, which is a document that says you come as a person, but also bring the documents that pertain, if there are any reports or anything like that. That usually comes in with examiners or any professional individuals that are going to testify other than lay witnesses. Or sometimes lay witnesses have information that they can present as well. And to have the assistance of counsel. Now that's the big ticket as far as the Sixth Amendment is concerned. There is a famous case, which, let me see, do they have it in here? Well, Gideon versus Wainwright, I'll tell you, that says that a person has a right to counsel. So that's the case that you will want to home in on, and just be aware that it exists. And it is Gideon versus Wainwright is 372 U.S. 335, and it's a 1963 case. It's a case, and I'll read from where I found the information. The Supreme Court unanimously ruled that the states are required under the Sixth Amendment to provide an attorney to defendants in criminal cases where individuals are unable to afford attorneys. So that's what that's all about, the assistance of counsel. So the Sixth Amendment provides protection during the criminal trial and the assistance of counsel. That's the big issue. That's why I made the statement that 4 and 5 are the big ones. 6 is kind of peripheral. And so, but remember, part of Miranda is you have to advise individuals that they have the right to an attorney. So it is a constitutional right to have an attorney at what we call critical stages of a criminal trial. So an example given here says if a person is pulled over for speeding, does not have a right to an attorney because probably they're not going to be incarcerated for that. However, if it's determined, though, that they are DUI, driving under the influence, then they possibly could. Nor does a person have a Sixth Amendment right to counsel when asked general questions by a law enforcement officer, stuff like their name and stuff like that. In comparison, if a person, as I said, back to this key word, in custody and being investigated and questioned about involvement, does have the right to have an attorney present at that particular time. So that's the extent to which law enforcement should be aware of the application of the Sixth Amendment, because you cannot question a person if they, unless they waive that right. And they must freely and voluntarily waive that right. Now, at some point, you can start questioning them, and then they can change their minds. And then you're going to have to then provide them and stop. You can't say, you can't even come back to them and say, have you changed your mind? Once they stop, it's presumed that they intended to stop. So, so in the Miranda case, the court said that law enforcement officers must advise suspects their right to counsel, and that it's, as I say, it's part of the warning that you're familiar with when you deal with Miranda. And then here it is right here. You have the right to remain silent. Anything you say cannot be used against you in a court of law. You have the right to an attorney. And if you can't afford one, one will be appointed to you at no cost. Then you ask at the end, do you understand these rights? Now, most instances now, as an aside for you, is that when officers provide the Miranda rights, most department policies provide the officers and detectives with what we call a pre-printed sheet. And the sheet actually is something that they use. And they will read these exact rights from the sheet. Why do they do that? Because if you misread it, or if you misadvise a person and you don't give them all their rights, you haven't properly Mirandized them, and that opens up a way for an attorney, defense attorney, to file a motion to have the information thrown out, even if one of those things are missed. And so, as a defense attorney, I would oftentimes ask an officer, did you provide the Miranda rights? And they say yes. And I says, could you tell me what those rights are? And I'm baiting the officer. I'm waiting for the officer to, remember, the officer's on the stand, might be nervous. And they will miss that one right. Let's say, for example, they'll say, even if you left, do you understand these rights? They left that off. They just stopped at one will be afforded, stop at yourself. And then I come back and I say, are you very familiar with those? And then I'll come back and make the person. And then the person will say, oh, I'm sorry, I meant to include that. As soon as the officer does something on the stand to make it look like they made a mistake, it swings in the favor of the defense. I don't care how small it is. It can throw the officer off. These are techniques that are used. Some people say, that's dirty. No, it's not dirty, because actually the prosecution's doing the same kind of thing with individuals as well when they question. It's the legal system and the process that operates in courts, and that's what the lawyers are there to protect those individuals. So an important point to remember is that law enforcement officers are only required to read the Miranda right when the suspect is in custody, and I explained that, and the suspect is being interrogated. And the way you know if someone's interrogated is you're asking them questions about specific issues relating to possible charges. Once the warning is read, the officer must stop the interrogation if the suspect does not wish to speak or request an attorney. That's what I said. So that's that's pretty much the idea about how that works. So if a law enforcement obtains evidence in violation under the Fourth, Fifth, or Sixth Amendment, and to kind of summarize this thing, the short answer is that the evidence can be excluded, because what we'll do as a lawyer, defense lawyer, is to file a motion to quash the evidence, or to a motion to suppress. And what we have is called the exclusionary rule, which excludes issues that are obtained in violation of the Fourth, Fifth, or Sixth Amendment. Going back to Weeks versus Ohio, and Mapp versus Ohio, where the exclusionary rule was extended. It says that evidence illegally obtained in violation of a suspect's right in a state court must be excluded. So the bottom line is this: police officers have to make sure that they are familiar with and understand those Fourth, Fifth, and Sixth Amendment rights. And there are a bunch of cases and so forth. And then there are many legal issues, which it's 8 now. I'm going to wrap up in a couple of minutes here. But be aware of the fact that I already said this. You presume innocent until proven guilty. The Fifth, Sixth, and 14th. The 14th Amendment applies to the states, but the Fifth Amendment and the Sixth Amendment, that's the presumption of innocence. And then it provides details explaining those things that are involved there. And I'm not going to go over those because you also have that already. So if you're going to be a criminal justice professional, you must operate in an ethical fashion. It is so important that you recognize that ethics is critical to law enforcement, and it goes across the board. And it lists from law enforcement officers all the way down to victim advocates, bailiffs, staff, attorneys, paralegals, defense attorneys, prosecutors, judges, probation officers, correction officers. Everybody in the criminal justice system must operate professionally and ethically. We've talked about that during the open house. That is actually one of our transferable skills that we encourage you to adopt as a way of life. And so criminal justice professionals are under in the spotlight, and there are instances where there is some unethical activity taking place. There are people who are going to jail who are law enforcement people or others because they operated in an ethical fashion, producing false reports, lying to in court, committing perjury, or just outright being indicted of crimes. And you should know that because we're in an era now where there's cameras everywhere, everybody's got one of these things now, and then there are cameras everywhere. Businesses have cameras, and many municipalities have cameras on the lights. There are cameras in stores, as you already know. So it is very, very, very important. So I'm not going to go over these criminal conduct disqualifying criteria. You can take the time to read these. These are North Dakota. But I can tell you that a lot of these things apply to individuals who are trying to get into the area of criminal justice. We do at this school run background checks, as you know already, and we tell people that in our school we don't even want you to come in and start classes and then with hopes that you can be a correction officer, a police officer, and so forth and so on if you have violated some of these things that are listed here. And so it is important that you follow ethical procedures in all of your work. Then finally, the practice activities, the abuse of authority for personal or institutional gains. You can type in your answer, but you can type in whatever and then hit the answer, and then it'll tell you what it is. So you have that, and that's a study tool. I recommend doing these questions in your own time, and as it says, it'll help you review the materials in your reading and in your lecture, and then I will add help you prepare your quiz. Okay, so I am obligated to give you a key phrase or word. Here it is. Get ready. Miranda. Or you can say Miranda versus Arizona, but Miranda. That's it. I've had students to call me and says, I didn't know what the key word was. I'm not going to say it again. I already said it twice. So you know what it is. Give it to me, and then I will know that you had the materials and that you've gone over the materials and that you also understood what was taking place during the lecture. Any questions before we adjourn? Any questions? Okay. Don't be shy. I was always the one in class. And whenever I would ask questions, I was known as the one that was going to ask a question. And guess what? Good. But don't type in privately, by the way. Whenever you type your answers in, always make them public so everybody can see them, so it's just to everyone, just for the future. But what I'm going to tell you is that because I ask questions, and I had people inevitably come to me and say, man, I'm glad you asked that question. And the professors would even say to me, thank you for asking the question. And, you know, there are people that say, oh, I should know this. I shouldn't even have to ask it. No, there's no presumptions or assumptions about that. I learned so much. And, you know, and after time, you will ask a question, and there are people who will smile or laugh. Well, I had a few professors in law school that if they did that, and you asked a question, then they would say, Mr. So-and-so, I saw you smiling and laughing. Do you know the answer to the question? And the person would go, well, I think I do. Well, no, don't think you do. Answer the question. And sometimes they would answer it yes, and sometimes they answer no. So Mr. Wright is indebted to you for answering that question. Thank you again, because you're going to learn to work with each other. And you don't know everything, and he's not going to know everything. And the professors used to tell us that all the time. And I tell my students that even right now, that there are times, I know this stuff, but I have to go back, and I know where to find the information, and I can go quickly, just like I found the citations to those cases. So don't be afraid to ask questions. No question is a dumb question. Even about the assignments, even if I've already said it, reach out to me, and I will not shoot you down. I will guide you and direct you. But what I will do is I might ask you a couple of questions like, did you read the material first? And I had a few students that say to me, well, I haven't really had the time to read it, but I wanted to know maybe if you can give me the answer. I said, I know you're not going to say so you don't have to go read it. I know you're not going to say that to me. But a student will, and that happens. It happens. Don't be like that. You're spending good money, guys. And my job is to not spoon feed you, but to guide you and direct you. Okay? I have responsibilities to provide you with good details and information to help you understand this information that is thrown at you. A lot of material, break it down so that you can understand how it works. And that's what I try to do in the lectures and in answering your questions. So with that, it's 8:10. I'm going to say good night. I hope to see you guys next week. Thank you for coming out tonight, and I'm going to end the session.